Luigi Mangione is now charged with first-degree murder of United Healthcare CEO Brian Thompson. Thompson was gunned down on a Manhattan street in the early morning of December 4th this year, 2024. We have two brand new and critical pieces of information that give us insight into what Luigi Mangione's defense is going to be and to whether it's going to work. Hi, y'all, and welcome to tonight's live stream. It's pretty typical for us to have a good idea of what the prosecution is going to argue in a criminal case. After all, they hold a press conference, they file documents like a complaint or charges, and they set out what they have. At least a lot of the information is available. But the defendant doesn't necessarily tip his hand. Just a defense here or there might leak out. Sometimes emotion will give us a good idea of where they're headed, but a lot of times we just don't know what the defenses will be until it's actually time for trial. But we have a very unusual twist in the events in the Luigi Mangione case because he has a new lawyer. Her name is Karen Friedman Agnifilo. She's a very good attorney with the Manhattan DA's office for 7 years. She was formerly a CNN legal analyst. And before she was hired by Mangione, the family, whoever hired her, before she was hired, she gave an interview to CNN, her old employer, or at least the group she had been an analyst for, talking about what she thought Luigi Mangione would be likely to use when he defends himself. And so the first piece of information we have is a window into a normally very private decision-making process that we often don't see into until time for trial, a peek inside the mind of the defense lawyer. So the second piece of information we have is the manifesto of Luigi Mangione. It was found on him when he was arrested at the McDonald's in Altoona, Pennsylvania. So tonight I want to cover three things. First, why I think Mangione may use the insanity defense. Second, I want to talk about what the insanity defense is and how it would work here. And then thirdly, I want to talk about Luigi Mangione's manifesto, as well as some of the other evidence, and try to figure out, okay, how good an argument is this going to be? How strong is an insanity defense going to be in this particular case? So that's what I want to cover tonight. I want to give a special shout out to the first 5 in the chat tonight. Maria Z, Rita Young, Abby, PJ1, L. Jane, and 10 Talks. Thanks so much. And welcome everybody. Tonight, right after this live stream, as soon as I can get it queued up and ready to go, we're going to be having a members only event. We're going to be having an online Christmas party / holiday party. And you, members of our regular members of our channel, have sent in photographs and also some of your favorite Christmas memories or traditions. So I'm going to be talking about those. We're just going to be hanging out right after tonight's live stream. If you are a member, just be sure to have your notifications on. You can always just go to the channel itself and it will show up as an event ready for you to click on if you're a member. So I'll look forward to seeing you all then. All right, so this is why I think that Mangione may use the insanity defense. Here is what his attorney told CNN before she was hired. Really unusual to have an interview by an attorney before they get hired then to represent the defendant. So in this case, this is what she said. It's a quote. "It looks to me like there might be a not guilty by reason of insanity defense that they're going to be thinking about, because the evidence is going to be so overwhelming that he did what he did." It's like, oh, wow. So his attorney already admitted on television that the evidence against him is going to be overwhelming that he did what he did. In other words, I assume she means overwhelming that he actually shot the CEO of United Healthcare, Brian Thompson. But so if you want to know what this overwhelming evidence is, if you want to know what the evidence is in general that we already know about, I did a video on that. As soon as this video processes from YouTube, I'll link that at the end. You can also see it on my channel in the playlist for Luigi Mangione. But this was insight, not just into her statement that the evidence is going to be overwhelming, but it also was a statement about what she thought the defense would be likely to be. In this case, she said it's likely to be, or she seemed to be suggesting they would be thinking about an insanity defense. Now, this is before she represented Luigi Mangione, so she obviously wouldn't be held to this, but she is, in fact, the attorney. So I would guess this is pretty likely to be what she's going to be thinking about as she heads into representing him and considers it. That's very unusual to get that sort of feedback before somebody takes on a case. But at the same time, we also, as I mentioned, have Luigi Mangione's manifesto that's been leaked to the public. It's going to, I believe, dramatically affect this insanity defense. We're going to take a look at the insanity defense, what it looks like in New York, and whether it might work to get Luigi Mangione off in this particular case. So what I wanted to start with was a jury instruction that's used in New York. And just a second, I want to say thank you to Bama Queen, who has been a member for 10 months. For anyone who's a member, don't forget about the live stream we are about to have right after this. So thank you, Bama Queen. All right, so let's head into how the insanity defense will work in New York. And this is the jury instruction. So I thought that would be particularly useful for us to look at because this is what the jury is going to be told. This is the instruction that they're going to get if the insanity defense is made in this case. So let's look. I've pulled out a few things that I thought were particularly important to talk about. Under our law, the defendant has the burden of proving an affirmative defense by a preponderance of the evidence. Now, what that's saying is, normally we talk about how the defendant is innocent until proven guilty, that the state bears the burden of proving that the defendant is guilty. It's the opposite with a defense. With a defense, the defendant has to actually prove it, but only by a preponderance of the evidence. It's not like the state. The state has to prove that the defendant is guilty beyond a reasonable doubt. All the defendant has to show for an affirmative defense is a preponderance of the evidence, that it's more than 50%, in other words. Now, under our law, and I'm continuing to read, under our law, it is an affirmative defense to the crimes charged that when the defendant engaged in the prohibited conduct, she lacked criminal responsibility by reason of mental disease or defect. A person lacks criminal responsibility by reason of mental disease or defect when, at the time of the prohibited conduct, as a result of mental disease or defect, that person lacked substantial capacity to know or appreciate either the nature and consequences of such conduct or that such conduct was wrong. So think about what the elements of that are. It's by the result of mental disease or defect. The person lacked substantial capacity to know or appreciate. That means they just literally weren't able to know or appreciate that the conduct was against the law or that it was against commonly held moral principles, or it can be both. Fifth, with respect to the term wrong, a person lacks substantial capacity to know or appreciate that conduct is wrong if that person, as a result of mental disease or defect, lacks substantial capacity to know or appreciate either that the conduct was against the law or that it was against commonly held moral principles, or both. And there are several ways that a person might prove this. One would be opinions of psychiatric witnesses. Another might be prior hospitalizations of the defendant. The third would be hospital and other medical records. The fourth would be the nature and manner in which the crime was committed. And then the fifth would be something that just is particular to that case, that's dealt with and specified there. Two questions are going to be, did the person have substantial capacity to know or appreciate either that what they did was against the law or that it was against commonly held moral principles? That's what the issue is. Not what the person believed, not what the person thought should be the law, thought should be commonly held moral principles, but were they able to tell that it was against the law? Were they able to know that it was against commonly held moral principles? That's what the standard is going to be. So that's ultimately what the jury will be asked to decide. So let's talk about whether he has a realistic shot of getting off by pleading insanity. And I want to go into this, his manifesto. Now, this was initially, apparently, numerous news organizations had this manifesto. It was found with Brian Thompson, who was killed, with Luigi Mangione when he was captured. But for some reason, the media quoted from it, but they never published the whole thing. It's not real long, but it was finally published by Ken Klippenstein on his Substack. And then it was confirmed by Newsweek that this was actually, that they were able to confirm with law enforcement authorities that this is truly what exactly it was. Sorry, I'm being distracted by the chat over here. I'm going to stop looking. Okay. So it was Newsweek confirmed with law enforcement authorities this really is his manifesto. So that's what I'm basing it on, the idea that this is going to be his manifesto. So let's read through it and sort of analyze based on what exactly his statements were. How does the insanity defense fit with that? Does this help his insanity defense, or does it tank it, make it really difficult for him to do this? So let's start with, to the feds, I'll keep this short because I do respect what you do for our country. To save you a lengthy investigation, I state plainly that I wasn't working with anyone. So what we're going to do with each of these statements through his manifesto is ask ourselves, does this show that he knew it was against the law, what he had done? Does it show that he knew that it was against the moral standings within the community? So that's what we're going to be asking ourselves. So did he know it was against the law? Well, this gives the prosecutors a pretty good argument that he did, because he figured there was going to be an investigation, that law enforcement would be looking for the person who did this. He also figured they might suspect other people were involved. The implication is he thought authorities would be looking for those people also, not just for him, but for other people as well. Specifically, he seemed to think the feds would be doing this. Now, did he know it was against commonly held moral principles? Again, this sort of helps the prosecution, I think, because he seems to think that the feds, on behalf of our country, will be investigating, that they'll be looking to see whether others were also involved in order to hold those other people accountable. And he was trying to save them the trouble to say, yeah, they're not. It's just me. I'm acting alone. So the question, remember, is not what he thinks is right, but whether he knows it was against commonly held moral principles. So I think this statement, right off the bat, is going to hurt his defense, his insanity defense, a great deal. Now, let's keep reading. This was fairly trivial. Some elementary social engineering, basic CAD, a lot of patience. The spiral notebook, if present, has some straggling notes and to-do lists that illuminate the gist of it. So this shows the ability to plan. In other words, he wasn't so psychotic that he was disorganized or unable to think clearly. Instead, he was able to plan. Now, that's not a deal breaker necessarily for insanity, but it doesn't help the government. I mean, it does help the government with showing his intent. He fully planned this. He intended this. That's another element that they'll be trying to prove. So, and was he able to tell it was against the law? Again, the prosecution has a pretty good argument here, because they're going to say he used elementary social engineering. That's what he writes down, that all he was doing was thinking logically about what people would be likely to do. He worked on it surreptitiously. He didn't call them up and say, hey, United Healthcare, was just curious, where will your CEO be spending the night? And also just wondered, when will he be in the open? You know, unguarded, and preferably on a street somewhere where I don't have to go through a metal detector. Just wondering when he would be there. He didn't do anything like that. And the prosecution is going to say that's because he knew that the community would find that unacceptable. He knew that people would not accept that they would think it was wrong, because he knew it was against the law. Now, he was much more subtle about it than just to call up and ask about it. It isn't like he thought whoever was answering the phone at United Healthcare would think this was just fine. Notice too that he's giving us an answer to a question a lot of us had, which is, how did he know where Brian Thompson was going to be? Was somebody feeding him information? Was there an insider who was giving him the information? Yes, Brian Thompson is staying at such and such a hotel. It was easy to figure out that Brian Thompson would probably be at the investors conference that day, but he wasn't even staying in the same hotel. So how did Luigi Mangione know that he would be staying near the hotel, where he would be walking, and generally speaking, what time of day? And what he's saying is that he just used social engineering. I guess he figured, well, he's probably going to stay somewhere close. Maybe he had scoped it out for a few days, figuring he would come up a few days earlier, and he had watched to see, do I see him enter the building? Something like that. In any event, what he says is he acted alone, that there was no one inside feeding this to him. Now, what does this say about whether or not he knew it was against commonly held moral principles? The prosecution is going to say, well, the reason he didn't just call up the United Healthcare general reception and say, hey, where's your CEO going to be, is because he knew they're not going to answer that. They're not going to approve of that. In fact, they probably are going to alert the authorities and ask them to figure out who just made this highly threatening call. It shows a knowledge of the way people think and behave. It's not out of touch with the way people think. Instead, it's in touch with the way the community acts and behaves. So my tech is, I'll keep reading here. My tech is pretty locked down because I work in engineering. So probably not much info there. I do apologize for any strife of traumas, but it had to be done. Frankly, these parasites simply had it coming. Now let's think through this. First of all, you can guess that the prosecution is going to use frequently these parasites simply had it coming, because it does seem very cold and calculated. It shows planning also, that he knew in advance what was going to happen, that he thought they had it coming in his own mind. Now, when he says strife of traumas, I figure surely he meant strife or traumas, but it does show his motive. He calls them parasites. It's very harsh. It's directed. It's a way of thinking about the victim. Now, one of the things I noticed is these parasites is plural. So he didn't know when this manifesto would be found. I mean, he didn't know when he would be arrested. It leads me to wonder, why is it plural? Was he planning more than one murder? Was he thinking he might be found after multiple murders? Or was he just maybe referring to United Healthcare? That's what he's going to focus on in the next little bit. He's going to focus on healthcare. So maybe he meant that company in particular. But I do want to get back to our two questions. Did he know it was against the law? Did he know it was against commonly held moral principles? And he is apologizing, which suggests he knows it's against community standards. He had a reason in his mind for doing this, but that is not the legal question behind the insanity defense. Instead, the legal question is not whether it should be against the law, whether it should be against commonly held moral principles, but whether it is in fact against the law or against commonly held moral principles. So I think the prosecution is going to be able to use this not just on intent, but on his understanding that, for example, he needed to apologize, that there would be adverse consequences society would be upset about. All right, let me say thank you to a few people. Thank you, Megan. Merry Christmas to you too. It is a fun time of year. I'm looking forward to our Christmas party for the members coming up next. Kathy is a new member. Welcome. I'm so glad to have you. You can join us right after this. Marla, what did I do with Santa? Yes, that's right. I'm pretty close to dress like Santa. I do have on red velvet, the fabric of the season, right? And thank you, Sunset Gazing, who gifted 5 lawyerly memberships. We definitely need to give out all 5 of those during this, because you can join us right after this live stream. So in the chat, Marlon, Mama Pinks, and Denise Pelton, who are 3 moderators, and I am so grateful to them, just as Megan mentioned, for they will tell you how you can turn on the ability to receive a gifted membership. You also can just hit the join button and you can join that way, unless you're on your iPhone. You can go to Safari on your iPhone and join from the browser. The join button is right down by the name of the channel, Lawyer Lee, right below this video. And that's where you can join. So I hope you will join us soon. And thank you, Sunset Gazing. Lynette, thank you so much. I appreciate it. And Donna has been a member for a month. That's awesome. We are so glad to have you. And thank you, Donna, for the super sticker as well. I appreciate that. Here we have another gift of 5 Lawyer Lee memberships from KS. Thank you so much. All right, so let's keep reading the manifesto. A reminder. The U.S. has the #1 most expensive healthcare system in the world, yet we rank roughly number 42 in life expectancy. United is the, and it says indecipherable, largest company in the U.S. by market cap, behind only Apple, Google, Walmart. It has grown and grown, but has our life expectancy? No. The reality is these, again, they wrote indecipherable, have simply gotten too powerful, and they continue to abuse our country for immense profit because the American public has allowed them to get away with it. Obviously, the problem is more complex, but I do not have space. And frankly, I do not pretend to be the most qualified person to lay out the full argument. So this is all how he is thinking about it. This is his thoughts about the state of the healthcare system. Frankly, I agree with a good amount of what he said. I mean, this is something on the U.S. health expenditure as a percent of GDP, that the U.S. has the highest health spending based on GDP share among developed countries. That and it talks about the reasons for that, one of which is physician salaries are higher in the U.S. than in other wealthy countries. In fact, twice as high as what other physicians earn in other high-income countries. And it's not that Americans use the health system more, it's that literally it costs more, and suggests that by 2031, healthcare spending will reach nearly 1/5 of the nation's gross domestic product, which is insane. It's not entirely a new phenomenon. This chart is a little misleading because you'll see that the first maybe 6 pegs go from 1960 to 2006. And once you hit 2009, 10, you're at the upper levels. But you can see the difference between 1960 and 2000, say, which is number 5, the 5th bar in there. It's steadily increasing, just rapidly increasing throughout that period. So yeah, I get it. I don't disagree with that. But that is not the question here. That is not the legal issue, but it will be a strategy of the defense. That's one of the reasons I put those slides in there, because what the prosecution will be trying to do is to lock out all of that discussion with motions in limine. Those are motions that ask the court to decide in advance that this or that evidence can't be used, that this or that argument can't be made at trial in front of the jury. The prosecution is going to want to focus on the shooting, on what happened on that street in Manhattan between Luigi Mangione and Brian Thompson, assuming they can prove that. The DA was even asked at a conference that he did, are you going to argue that some of this is not going to come in? How are you planning to deal with some of his reasoning and the why behind what he did? And they just said, well, we've got a really good team and we'll deal with that when it comes. But I would think they would be very likely to be filing motions. The defense is going to do just the opposite. They're going to want to use not just this paragraph, but some evidence and some proof behind it. They're going to want to look at graphs like that I showed you. They're going to want the jury to think and talk about the issues around healthcare instead of the issues around the shooting of Brian Thompson and whether or not Mangione is the one who actually committed that. So getting to our 2 questions, what does that sentence or 2 that we just read tell us about whether or not Luigi Mangione knew what he was doing was against the law or against commonly held moral principles? And the answer is not a lot. The prosecution may try to redact all of that. They may try to get the judge to leave all of that out and say, look, That has nothing to do with the shooting. Now, the defense is going to argue if you get in part, you should get in the whole thing. You can't just cut out sentences in the middle of this and use part and not use part. So that will be a battle that will happen in the courts. But ultimately, does that matter in terms of whether or not he knew what he was doing was against the law? No. The fact that the U.S. has higher healthcare expenditures doesn't mean he had no idea that a shooting would be against the law. It doesn't mean he knows a shooting would be against commonly held moral principles. They're separate issues, which is why the government will try to keep that out, and the defense will argue, no, it sits as a whole. You have to look at the whole thing. You can't cut out pieces and parts because it's all related to what he was thinking at the time. Now, the fact that I do want to mention too, some of the phrases he uses, like that the healthcare industry is too powerful, that large insurance companies continue to abuse our country for immense profit because the American public has allowed them to get away with it. Some of that kind of implies that the public might believe differently if they just woke up, if they thought about it. That pretty much admits that, at least for now, that belief is not commonly held, that people aren't commonly thinking that CEOs of healthcare companies should be killed. That's not a commonly held moral principle at this time. So he then goes on to say, but many have illuminated the corruption and greed, e.g. Rosenthal more decades ago, and the problems simply remain. It is not an issue of awareness at this point, but clearly power games at play. Evidently, I am the first to face it with such brutal honesty. Now, the defense will be really wise to talk about this because they're going to want to focus on the why behind what he did. They're going to want this to resonate with the jurors, for the jurors to be thinking about the issues around healthcare, because they may agree with him on some of this. And maybe that will change their focus. If the prosecution loses and these statements come in, now, will the jury let Mangione off because they're mad at healthcare companies? Could that even happen? In another video, I will talk about jury nullification. So be sure to subscribe to the channel with the notifications on, because I will be covering that, and you'll want to get notice when that video drops. But the legal questions are really pretty simple. What does this tell us about whether he knew what he was doing was against the law or against commonly held moral principles? Now, I'm assuming that he is making an insanity defense. I'm assuming that. Well, since he says he's the first, these aren't commonly held moral principles. He may believe society will or should move in that direction. He's not saying it's happened. The vibe is that it's different. It's unique. He's the first. He's outside the norm. He's not in the norm. Also, there's nothing that suggests that he's within the law. He seems to feel more like he needs to justify what he's doing. And then remember, the question is, did he have the capacity to know whether he was acting within commonly held moral principles? And the fact that he's talking about what the norms should be, what commonly held moral principles should be, suggests, for example, he says he seems to think what United Healthcare is doing is wrong. He thinks corruption and greed are wrong. All of that shows awareness of some actions being moral and some not. So I think that the prosecution will use all of that. Now, let me pull out and talk to you a little bit more, because I also want to cover some of the other information. And actually, let me pop back in. I want to show you, go back and show you one more thing. Remember, in the jury instructions, these things that might be presented at trial, opinions of psychiatric witnesses. I have no doubt whatsoever that there will be psychiatric evaluations done of him. And if so, they may well be presented at trial by both sides. Now, we don't know anything about the next two prior hospitalizations. And I think they're talking psychiatric ones, not, for example, about the injury to his back and the problems he had post-surgery on a problem with his back. I don't think they're talking about that. I think they're talking about prior hospitalizations for mental illness. and hospital and other medical records, that's just a missing piece for us. We have no way of knowing until trial what that information would be. Now, the last one, other than specify, which would be something specific to this case, but is the nature and manner in which the crime was committed. And I think we do have some information there that will help us evaluate the insanity defense and whether or not it's going to work for him. So first of all, we know from reporting by the media that he disappeared for a period of time. His mother even filed a missing persons report on him in San Francisco. And the San Francisco police then called the New York police to say, hey, the guy you are looking for meets the description of this person we were told to look for who is missing. So you should talk to his mother. And there was, in fact, talk with his mother before he was actually arrested the night before. In a press conference, the law enforcement said, and I think it was actually DA Bragg said, yeah, we talked to her, but she was not able to identify him from the photograph we had. She did say something, it was reported widely anyway, that she had said, well, it does seem like something he might do, something along those lines. But DA Bragg said none of that, she didn't need to identify him. None of that was relevant because they found him the very next day. And so it was not part of what led to his arrest in any way. So the next thing he talked about that I want to mention, not just that he had disappeared, and let me talk for a minute about the disappeared. Now, I think that might be probably the strongest fact helping with an insanity defense, because I think the defense is very likely to argue, he was having a mental break. He was completely separating from his prior life, from his prior way of thinking, and something was dramatically wrong. So much so he dropped off the radar, stopped communicating with people he normally did, cut off ties with his family, and disappeared for months on end. Clearly, that's some kind of mental illness break. I think that's the very best argument that the defense has. Now, the argument, I think, an argument on the prosecution side is apparently he talked about this for several months. Now, ABC, and this is a quote, said that law enforcement sources have told ABC News that writings seized from the suspect indicate he had been developing a fixation and increasing malice toward United Healthcare and allegedly talked about harming its leader for months. Some of the entries in the notebook seized from Mangione upon his arrest in Pennsylvania had dates on them going back to mid-2024, the sources said. So I think the prosecution will use that to say, look, this wasn't a momentary psychotic break where suddenly he just went a little nuts and did something crazy. That isn't what happened at all, that he'd been planning and thinking about this. And maybe he even went undercover in order to do this. Maybe he broke ties, not because he was having a mental break, but because he wanted to get away with what he was about to do. At least he wanted to break any ties that might link him to anybody else or cause them to be implicated in it. The next thing I think is that I think may play a role in it in terms of facts is that he seems fully aware of and in control of the situation. For example, the fact that he took flight, the fact that he fled from law enforcement and made it to Pennsylvania and evaded capture for 5 days suggests he wanted to get away with it. At a press conference, this is what one of the law enforcement said. This is from the New York press conference. But right now, I will tell you that based on everything that we have seen, he was very careful with trying to stay low profile, avoid cameras. Not all that successfully in some cases, but that was certainly the effort he was making. He took steps to try and avoid detection with some of the electronic devices and things as well. So again, all part of the investigation, but clearly somebody that was very security conscious and trying to avoid somebody. And then there were also other things. So in that particular case, they're saying he wasn't somebody who just thought, oh, I had no idea that anyone would think this was bad, which is what the insanity defense would be, right? It would be, he didn't know it was against the law. He was unable, he lacked the capacity to know that this was against community moral standards. He had no idea. The fact that he took flight that he took all of these precautions to avoid being seen on cameras will play into what the prosecution says about this insanity defense. The avoiding cameras suggests you know that you're going to be caught and maybe held to account if someone sees you, because they won't approve of what you did. The fact that he apparently, we've been told, had a burner phone and that law enforcement found DNA and a partial fingerprint on that. The fact that he used a burner phone, not his regular phone, again suggests he wanted to avoid attracting attention. His use of fake identities, because we know that he had a fake ID with him that is apparently what he used to check into the youth hostel he stayed in right there where he was staying in New York, not that far from where the murder occurred. The fake identities, they say, are again, that's an attempt to avoid detection, knowing apparently that he would be caught and that society would have different moral standards than what he was showing, that what he was doing was against the law. And then finally, the fact that he wore a mask at all times except for that one lapse in judgment when he pulled it down to talk to a worker at the youth hostel. Except for that, he wore a mask, again, trying to conceal his identity. So for all of those reasons, I think this is likely to be a defense that Luigi Mangione uses. I think that because the person who actually was hired to do his defense said that would be a very likely place that an attorney would go when the attorney was hired. I think it's going to be a very uphill battle for Luigi Mangione to make that argument in light of his flight, the precautions he took, and the manifesto that he wrote and what it says and shows about his thinking. It's going to be a very tough, very uphill battle, as it always is. It's a very difficult defense to win or to be successful with, but I do think that that he's likely to try to make it. So I'm ready to answer a few questions now. If you have a question, if you would put your question marks at the beginning of your question, it will help me spot it in the chat. I'm going to go over here and freeze. Okay, so I can hopefully find them right away. All right, let's see. There are a few more people. Lynette, thank you. Yes, thank you. Please do hit the like button. I always forget to say that. So thank you, Lynette, for reminding everybody. I would appreciate it. It's a completely free way, except for Lynette. It's a completely free way to help the channel and to help the video get out to more people. So thank you very much. I appreciate that, Lynette. All right, so let's take a look at what the questions are. Frocky asking me, does a successful insanity defense really mean that one walks? In Germany, it mostly switches prison with a closed psych ward. And while life means usually 20 years, insane can really mean life. So you have a good point, and it varies. We recently covered a case where we talked about what it means in Georgia. And frankly, it doesn't mean, it definitely means exactly that if someone was not guilty by reason of insanity, there is an evaluation of what treatment they need. They are sent for that treatment. There is a process to reevaluate. I don't know the process in New York, but that's pretty typical. In most cases, the person doesn't walk free. There's an evaluation of what treatment they need, and they're given that treatment. And that treatment continues for as long as they continue to need it, which, as Frocky mentions, could be even for life. It could be that the person continues to need that. Shy Gal, could this defense give a different avenue to jury nullification? Curious to hear your thoughts. Shy Gal, I think it's a really good question. It's such a good question. I'm going to do a whole video on the jury nullification issue and what it means and how it might apply. The basic principle behind that is the idea that the jury makes a decision based on what it believes to be correct, as opposed to what it believes the law would require it to do in that particular situation. So will they argue and push for that? I think that they won't overtly argue that. I don't think they would do that, because typically most judges wouldn't allow an overt argument that, hey, you should ignore the law. Don't pay any attention to that. Instead, do this other thing. But it will be implicit in the way that it's talked about and in the way the whole issue around healthcare is discussed, if they're able to get that in. We'll talk about that more at a different time. in another video. RMAC is telling me the Sarah Boone case docket has been officially closed. We covered her yet additional letter. I'm sure the judge was thrilled to close that out and not to get any more letters, at least for a while. Carrie and Luke's channel, thank you so much. I appreciate that. Loretta Powell, is there any ethical problem with taking a client when it's already spoken publicly about? It's unfortunate. I would put it that way, Loretta. I don't think there's an ethical problem with it. She didn't say anything. Well, she did say that the evidence would likely be overwhelming, but I don't know. It's such a rare thing. It just never happens. She had no ethical duty to avoid talking because she wasn't representing him at the time. And as long as she disclosed what had happened, then I don't think there's any ethical responsibility to not take the case. Was it wise? I think it's probably okay. I think just about anyone would say the evidence is probably overwhelming, and she didn't guarantee that it was. I'm trying to remember her exact language, so I'm going to go back to that. It's pretty important. Let's see exactly what she said. All right. It looks to me like there might be a not guilty by reason of insanity defense that they're going to be thinking about because the evidence is going to be so overwhelming that he did what he did. So I think that's a tough thing. It's going to be hard for her, but also know this, that statement is not going to come in at trial. Though nobody's going to be allowed to say, hey, even his lawyer thinks the evidence is overwhelming. It might get put into a brief here or there, but probably not even that. And it definitely, I cannot imagine the scenario where that came in front of the jury. They're just not going to hear that. It's not going to be part of it. All right, looking for question marks. I don't understand why folks are confused that he will be tried as a terrorist. Kat, that is a really interesting question. And the reason is because there was the new charge for first-degree murder is related to the charge that this was a terrorist act. I'll go over that in another video too. I have a bunch of specific information about that, about what the statute was, why it got changed to that. They were taking him from second-degree murder, which is how he had initially been charged, that had been in the arrest affidavit. And then they were moving it to first-degree murder. In New York, there are specific things that are covered by first-degree murder. For example, killing a police officer or killing a public official might be things where it meets this exact standard. One of the standards is someone committing that terrorist act, and that's what they're talking about. But it merits a lot more discussion around that. I'm just giving you kind of a basic overview. So good question, and we'll talk about it some more. Thomas, any comment on a selected attorney? I hear she's an excellent attorney, and I'm sure she will do very well for him. This is a very, add a bunch of various difficult case. Let's face some facts. So, but she apparently is up to the task, and I'm sure she will give him the best representation she possibly can. Eat the food, Tina. Do you think it will be difficult to find an unbiased jury? Sure. Yes, I do. Anytime you have a really public case like this, it's difficult to find an unbiased jury. And in this case, it's going to be even more difficult because there's the motive overlay, this motive of the need to eliminate, to punish healthcare corporations that are harming America. So it's going to be very difficult. They're going to have to be asked not just questions about their knowledge of this particular case, what they have heard and know about Luigi Mangione and the charges against him. They're also going to have to answer questions. What do you know about, what do you think about healthcare? What are your experiences with that? What are your experiences with United Healthcare or other big corporations doing healthcare in America? So all of that is going to be part and parcel of getting a jury. WB wants to know, can you please tell us the date his security chief was let go? I don't know that. Interesting question. I didn't know that was true. Mother Oates, can United Healthcare records of claims management training practicing be subpoenaed by the defense at all? I would imagine the prosecution would argue against anything like that. The prosecution is going to say none of that matters. It doesn't matter at all what the company he worked for did. What matters is, was he shot by this person on the street? And if he's mentally insane, Does it fit in those criteria? The way United Healthcare paid out policies is irrelevant. That's what the prosecution is going to argue. I'm not aware of facts that would make it relevant, but there may be some. And so we'll just have to kind of wait on that sort of issue to find out more about what the defense is going to argue. Buckwheat, will you do a live after Delphi sentencing? Will those involved in the investigation and jurors be legally allowed to speak as to their inside knowledge as related? So Buckwheat, for those of you who don't know, the sentencing is 2 days from now. It begins on, I'm pretty sure, the 20th, and I think she's allowed 2 days for it, but at least the full day. And she's put out pretty much the same order as before, which is media will be in the front row, family will be seated, and anything left over will be for members of the public who wish to see, which would be everybody left over in the media not getting in the front row, as well as any YouTubers or anybody else. I will not be able to attend in person. I am trying very hard to talk to a couple of people who are attending in person to try to get them to come on the show and to talk to us live shortly afterwards about what happened and what their experience would be. So if I can possibly do it, I definitely will, because obviously all of us who followed this case so closely would like to know what will happen. I think I can pretty much tell you what's going to happen. I think he will be given life in prison. I don't think there's much question about what Judge Gull will do, but there are questions around what evidence will be presented by both sides related to the sentencing. So that part is as yet unknown. Okay, Holly. It's her first time on the channel, but she finds this case interesting. I do as well. I think it's really fascinating. She has a background in healthcare and psychology. All of those things. This is a case where all of those things mix together with the legal system. And the question will be, how much of that will come in at trial? And how much of that will the prosecution be able to say, no, that's not relevant? All that's relevant is the shooting, the killing, and whether or not if they do the mental insanity defense, if they met the standard under the law. But I totally agree with you. I think it's very fascinating. And I think that many people in the country agree with you. I did a post on X that went mega viral. And I think the reason is because people are fascinated by this case. And what I talked about in that was my concern about his statement that evidence that was supposedly found on him was not evidence he had. It was a special concern because he didn't seem to object to all of the evidence. He seemed to basically, oh yeah, okay, I had that and that. But this I didn't have. And that obviously was a concern. That's something we need to learn more about. So we will find out about that in the coming months, I hope. Gloria S. asked me, what happens if Sarah Boone writes more letters and the file is closed or they return to her? Well, typically when this file is closed, the appellate file is opened or soon will be. And so she'll file in the appellate case. That's what I would expect. So the notice of appeal would be filed up in the appellate court and she would be able to file her letters there, where they will be given absolutely no attention. It's my guess by the court. They will not be moved in any way by her letters. They're going to say, nope, you do briefing here. You do it in a certain order at a certain time. You're given a certain number of pages. You don't get to just write letters. That's most likely what they will probably say. Leslie asking me, will I attend this court case? I don't know. I imagine it's a couple of years out. So, but maybe it certainly would be absolutely fascinating. So I'll be following this case right on. All right, Jack asking, isn't it possible that someone with a mental illness could know that his actions are illegal and unacceptable to others, but still believe he is morally right and justified? Jack, absolutely, 100% yes. And it doesn't matter. The law only cares about whether they know that the actions are illegal and unacceptable to others. That's all that matters. That's all the insanity defense is about. That if you believe you're morally right and justified, that's irrelevant. So, and you're right that mental illness could have a lot of components beyond that, but that is not legally what matters. It's not that broad. Okay, let's see. I'll do a couple more. All right, Courtney asking, so did Luigi use the same ID in the hospital he stayed at and the one he showed the police at McDonald's? If so, then he is guilty. Um, Courtney says. My understanding is yes. And I say that based on both what was stated when he was arrested and by a statement made at the press conference that it was the same he had used when he went to the hospital. So I think that, yes, he had the same one both times. I don't think that alone would prove that he was guilty because they've got to trace that ID to the person who actually did the shooting. I'm not saying they can't. I'm just saying in and of itself, I don't think that's enough to say he's guilty. There's got to be more around that, I think. And I'm looking for, yes, please do hit the like button. Thank you for the reminder. Megan asking me if I've heard of Jared Murray. I have not, but I'm always looking for, I assume that's a new case. I'm always looking for your input on new cases. So please write me. You can find my email in you can find the channel email if you go into the information about my channel. And I am always looking for new information. You can also put it in the chat and the moderators will let me know about cases that particularly interest you. Sunset Gazing is asking, is he part of a group, radicalized, comfortable, communal living, that kind of thing? Could that have given him courage? So Sunset Gazing, I don't think anybody knows all of those details for sure. I know there were references to him being part of a Reddit group of people who talked about the problems with getting coverage for the kind of back pain and back trouble that he had, the condition he had. But that's pretty far from being a radicalized group. I think that was more just people who were talking about the medical issues and maybe the coverage issues, but not people who were talking about murder or killing CEOs or anything like that. So I don't know of any group that he was necessarily a part of. We'll have to find out more about that maybe in the coming years. Holly Winchell is a new member. That's fantastic. Glad to have you. Speaking of, we are about to, I'm going to, when I shut this down, I'll open up the members only live stream. It'll take me a few minutes to get it ready. So roughly 8 o'clock or so, maybe 8:05. And you'll get notification if you have the notifications on, or you can just go to the channel. And if you're a member, it will appear right there and you can click on it just as you normally do. We're going to be having just a Christmas holiday party, having some fun, and have a little Christmas game plan. We're going to be looking at pictures of people's Christmas celebrations, talking about their holiday traditions for other members on the channel. And I'm really looking forward to that. So thank you to our mods. I appreciate your being here tonight. And I will see you. We go live Monday, Wednesday, and Friday at 7 p.m. Eastern. So I will see you on Friday at 7 p.m. Eastern. We are off next week for the holiday.